Good afternoon, everybody. My name is John Keenan. I'm a principal with BRI Ferrier. We're here today to do the next session titled Commercial Disputes and Restructuring Outcomes. Today's topic will focus on proprietary companies, small to mid-sized businesses, where there are, in our experience, disputes that leak in from shareholders and management, directors. And what that does is it creates disruption for the business. Those disputes lead to forensic requirements, which I have a panel here today to talk to on those points, and obviously a large range of legal matters, including litigation, and we have a lawyer here today to talk to those points. Like always, or in our talk, we always speak about it, early intervention creates better outcomes and opportunities. Today's topic will focus on the journey and how those early interventions will create those opportunities for people. Today's outline, if I can just briefly talk through that, will be an overview of the COVID market as we're currently seeing and our observations of that. Common areas of dispute that we're seeing in the market and those matters that are coming towards us. The legal options to manage those disputes. There's a judicial focus when determining disputes, and so what we're seeing the courts focus on. What are we also seeing in terms of the evidentiary considerations and how that might relate to the forensic type reports that one of my colleagues here will talk about? What outcomes the court can see and provide for people in dispute, and then the alternate options that are there for restructuring, and that's more where I come into play on the restructuring side. I will say this is a general discussion. This isn't advice. So we please ask you to treat our comments in that vein, seek professional advice as necessary. Questions will be at the end, but please use that chat box, which is there available to everybody. Let's get going. I'd like to introduce our panellists today. Our first panellist is by the name of Paul Croft. Paul is a forensic expert and he is a director with my firm, BRI Ferrier. He's the head of our forensics division. He has over 20 years experience in forensics, financial due diligence, financial reports, financial control, and finance transformation. There's a lot of finance involved there. There's accounting focus. He is a bit of an accounting savant, if you will. He's very good at data analysis, financial modelling, forecasting, and structure operating model reviews. I have also seen him do forensic analysis as well on particular matters, and the skills are there. Paul is regularly engaged to prepare independent expert reports for litigation matters and valuation reports. That's both pre-litigation and post, or for that. Paul, thank you for joining us today. Our second panellist is Hannah Griffiths. She's a lawyer who I've worked with for many years on a range of restructuring matters. Hannah is a principal and the head of insolvency and restructuring at the law firm Gilchrist Connell. They're dedicated specialists in insolvency and commercial recovery. We use them a lot in our voluntary administration and receivership and liquidation matters for that matter. Hannah is a senior corporate litigator with particular experience in corporate insolvency restructuring, as well as construction, corporations, securities, equity, and trusts. Hannah has a broad range of varied experience in litigation and dispute across resolution matters in Australia. In her career, Hannah has acted for construction companies, insolvency practitioners like myself, large corporate creditor corporations, SMEs, debt collection agencies, corporate and individual lenders. She has all the relevant qualifications, law degrees, members of INSOL, and is actually a member of the Australian Restructuring and Insolvency Turnaround Association, which I'm a member of. She's actually on their committee for New South Wales and the ACT. I'll chair the session today, and I will have some input at the end, but I'm a registered liquidator and I'm a principal with BRI Ferrier. I've been practicing for over 20 years on a range of commercial and restructuring matters. I've done a lot of work in the financial services space, retail, insurance, manufacturing, clubs and charities restructuring too. Our business focus is on corporate recovery and restructuring, and so trying to give those businesses a chance to save themselves, whether that's by virtue of helping them resolve disputes involving litigation pre or post, and trying to bring some commercial reality to bear in otherwise sometimes emotionally charged situations. Those formal appointments that we get involved in, I particularly get involved in, is voluntary administrations, which usually involve a deed of company arrangement to restructure their affairs, or in some cases receiverships to take a position for a particular secured party or on behalf of the courts. Over the years, I've introduced new capital partners, funding, management, excised underperforming elements, staffing, or otherwise as a part of a journey to restructure a business and set it on its way. Again, I'm a registered liquidator, a chartered accountant with degrees and members of both ARETA and the Turnaround Management Organisation in Australia. So today's discussion will run as a panel discussion. And I'd like to start, if I could, by introducing the topic of where we're seeing the current market. The COVID over the last 18 months has led to substantial disruption in a range of matters in the business environment. Certainly from my end, we've seen it in both mid-market down to small. But from a position where we'd seen it as COVID has been drastic and detrimental, the government's initiatives and funding has largely flattened that curve that we saw and that cliff that was coming. There's been strong economic growth, there's been low unemployment and cheap money in particular, which has actually been allowed a lot of businesses to weather this storm that's been over the last time. That said, we've also seen a K-curve in this economy. There's been a lot of winners, a lot of losers. And I've been quite busy over the last year with Paul's involvement on a range of matters where we've seen those that haven't been on the right end of that curve, if you will. Uncertainty creates disruption and concern for businesses in this environment. Government support has now ended, debts are being called up, and albeit that we're in lockdown again in Sydney and the government's released some new measures, there's a substantial strain on a range of businesses, in particular in retail. That's what I've seen in the market. Can I turn over, Paul? What are you seeing from the forensics perspective and disputes?
Thanks, John. I think it's a pretty good summary you've just given about the current environment. But before I jump into talking about the types of disputes I'm currently seeing, I think it's really important to understand what are the motivating forces behind some of the disputes, because it helps me as a forensic accountant to really understand the nature of the dispute and also looking for pathways to actually help resolve those disputes in a fairly efficient and effective way. So you're right, we're seeing a very challenging and uncertain operating environment where cash flow has become quite tight and businesses are trying to conserve that cash. And so they're at a company level. This is leading to reduced payments to directors or shareholders versus in terms of their remuneration, take-home pay, distributions. We're beginning to see, or I'm hearing stories of unfunded loans, which is creating some Div 7A issues for directors from a tax perspective. And I'm also seeing like the cash-strapped directors and shareholders those that might be cash-strapped, looking to realise the value in their business through an equity sale to a business partner or a third party. So while these dynamics are playing out, we're definitely seeing an uptick in director and shareholder disputes. On the one hand, the disputes could be centred around the way that they might be remunerated under their agreement. But on the other hand, we're seeing disputes about how the equity should be valued for shareholders looking to exit the business, and often with material differences in their valuation expectations. And we'll talk about this, I think, during the panel. There are some overtones of oppression as some shareholders seek to leverage their stronger position to the detriment of their business partner.
Yeah, right. Wow. There's a lot going on there at the moment.
Yeah.
It's always, well, we see it when there's a lot of value there, there's always an argument to be had as to who gets what part of that pie. Hannah, what are you seeing on the legal side?
Yeah, thank you, John. Echoing some of the comments Paul made, there's definitely been some concerns around cash flow for a lot of businesses. I've seen an increased inquiry in respect of directors being concerned about discharging their obligations to their entity. Most of those concerns stem from an inability to forecast cash flow due to the situation in the economy where they're in lockdown, out of lockdown, their stores are open, their stores are closed, issues concerning commercial leasing, negotiations with commercial landlords, issues with managing employees. So there's been an uptick in employee disputes, some of those arising from redundancy, some arising because their workplace conditions are being varied so often. So as Paul indicated, when we're looking at what's been happening in the economy, it's really good to understand the drivers behind what's going on, and some of that is the inability to predict the upcoming circumstances. And as a consequence of that, together with people or corporations experiencing poor cash flow, we've seen an uptick in disputes. The other area where I've seen a lot more activity is in terms of collection of debt. So many of the people that will be on this conference will be aware that there was a temporary moratorium on debt collection practices introduced by the Commonwealth Government, which stretched out the period of time in which debtors could respond to demands for payment of debt and precluded any creditors pursuing it. That moratorium's over, and so we've seen an uptick in winding up applications and obviously separate appointments such as provisional liquidators over some of those jobs as a result of that debt collection increasing as well.
And with the upcoming election at the end of this year or not, we'll see whether the ATO actually starts to join that journey. But they have to date been sitting back. Guys, I'd like to move on to what are you seeing? If I'll throw this one to Paul, what are you seeing as the common areas of dispute? Maybe even the key warning signs that you're seeing in some of the elements there.
Okay, look, it's fundamentally, and it's probably not a surprise to many people who work in the area of mediation and ADR, that a lot of the disputes arise because of ambiguity that exists within their shareholder agreements. And that's typically around the accounting terminology or how business or how equity should be valued when a shareholder wishes to exit the business. So, I guess in my experience, when business partners come together, everything's really good at the beginning. They're all happy. Things are moving along in a very nice way. And it's not uncommon for them to cobble together a shareholders agreement that they think is actually describing what they want, and they know they have an intention behind it. But it's when the business or the relationship starts turning sour. And I consider this for one example. I was involved with a dispute over a payment to a director/shareholder. The clause in the agreement read, the defendant's payment or the director's payment for holding the directorship shall be 25% of the declared net profit issued to directors and shareholders, or a sum equally agreed between the two. And when I'm brought into disputes like this, I can't have any regard to the intention of the parties. I can really only interpret it pursuant to applicable accounting policies, terminology, standards, and the like. So, but in this example, not only does that phrase declared net profit confuse concepts around profit and dividend, but the shareholders agreement was equally silent on what it actually meant by net profit. To the layperson, not accountant, net profit is probably just incomeless expenses. But in this case, one of the directors intended it to mean income, less expenses before payments to shareholders and directors. So, that's a great example of why it's important to get your terminology correct. But the post-acquisition disputes, whether that's around the completion accounts or whether it's over earnouts, are much more complicated. Now, having spent many years in M&A advising clients on how to construct their sale and purchase agreements from an accounting perspective, as well as experience in resolving accounting dispute or post-acquisition disputes, there are some really straightforward ways that could mitigate the disputes at the front end. But on the flip side, they also guide how I can then proceed with resolving the dispute. When we go through accounting, there's typically the first step is there is a hierarchy that should be there in terms of accounting policies and frameworks. The first one is, be specific about the accounting policy. So if the company has work in progress or it has accounts receivable and there are impairments, be clear around how they're accounted for. Because often you'll find that, work in progress may not be recorded in an SME's business, but when it comes to valuation, you really need to take account of that. Often the shareholder agreements are silent as to the type of accounts that need to be prepared in the event of a dispute. And so they include words like special purpose accounts, general purpose accounts, management accounts, statutory accounts, company accounts. Each of those things mean very different things in a different situation. So when you've got that in a shareholders agreement, which is very generic, it actually creates more problem. And the third one in terms of that hierarchy is that you really want a catch-all phrase that says accounts must be prepared in accordance with GAAP, Australian generally accepted accounting procedures. So when you've got that so when I'm going through a dispute from an accounting perspective, they're the sorts there that I follow that order. The second one is the clarity around accounting definitions. As I said in that example a moment ago, not defining net profit or what's really meant is quite a big mistake. And the third one is making sure that there is sufficient detail in the agreements as to how an accounting item needs to be calculated. And I've seen them where you actually go through maybe a page. You just need to take as much time as possible, particularly around might be construction work in progress, all those sorts of more complicated accounting areas. It's really important that the calculation methodology is set out in the agreement. If you don't have these, it just broadens the scope of disagreement, and you get different values, and it becomes a much more expensive process. So
I wonder there if it's the drafter that's maybe not understanding in detail some of the key accounting concepts and how they might be interpreted 3 years, 5 years, 10 years later on. Is that your experience?
Yeah, absolutely. And it doesn't matter whether it's 6 months or 5 years, but it is that's why I said about the types of accounts you prepare. If you're thinking, you don't think today, you think, well, in the event of a dispute at some future point in time. So you really need to be clear. I mean, it's hard because, businesses are evolving, but as long as you capture the core accounting and the core accounting practice in the agreement, that kind of limits the scope of dispute. The last part is around the shareholders agreements, which are often silent on how a business or how the equity needs to be valued in the event of an exit. And this is, you would think by now businesses with actual drafters, whether that's the accountants or the lawyers, need to come together to actually set this up, because you really need to have, when you're thinking about evaluation approaches, capitalisation of future maintainable earnings, is it a discount cash flow method? What are the sorts of multiples? What sort of discount rates? I mean, we have, accountants can have, long debates about the theoretical approach, whether you have a liquidity discount or whether there should be a premium for control, all those sorts of things, which you don't really want to have to leave to the dispute end, that you really should see in the agreement. As again, you don't have this, you just can actually spend a lot of time debating over 25 basis points in evaluation. Hannah,
can I bring you into this discussion now? What are you seeing from the legal options when these disputes are coming about, and perhaps how that's relating to what the courts can do?
Yeah, thank you, John. So the court's jurisdiction is enlivened, or the court has the ability to make orders when they're satisfied that the company's affairs are being conducted in a way that's contrary to the interests of the members as a whole, or in circumstances where there is oppression, unfair prejudice, or unfair discrimination against a member, whether in their capacity as a member or in another capacity. So in light of that, when the court does have jurisdiction, there are parties that will apply to the court for various orders under the Corporations Act and specifically Section 233. The court has really wide powers to do a range of different things, and it's important to understand that those wide-ranging powers enable the court to be flexible and also to do justice as between the parties, interfering as little as possible with the ongoing affairs of the corporation, and indeed various judicial remarks are made about that. So there is the extreme step that many applicants try and take by making an application to wind up the company. The court can also make orders to modify or repeal the company's constitution, and often, as Paul touched on before, there are disputes arising from the lack of drafting particularity in either a shareholders' agreement or the operation of the constitution as to what requires a majority, for example, to pass a resolution of the company. The court also has got power to regulate the company's affairs in the future, make an appointment of a receiver over any or all of the company's property, and also restrain a person from engaging in conduct or from doing a specific act or requiring a person to do a specific act. So that's really regulating the affairs of individuals connected to the company. So those are the sorts of orders, John, that a court can make, provided that the jurisdiction's enlivened.
Yeah, our experience has been the courts will try and not involve themselves too much in a commercial dispute unless they can demonstrate prejudice. But what is the court? Well, let me get out. I'm not a lawyer. So what is the court focused on from your perspective when these things are coming out? What's the key objectives?
Yeah, absolutely. So the central focus of the court's attention when they're looking at these applications by parties, and that application might be a disgruntled shareholder, it might be a minority director in the context of a company, it might be a couple of directors, or it could be a group of shareholders. The court's really focused on looking at whether the conduct that's being complained about in the eyes of the objective commercial bystander involves some level of unfairness, commercial unfairness, or where what's being complained about involves a departure from the standards of fair dealing and a violation of the conditions of fair play, or if the decision that's actually taken place in the company, for example, to terminate a supplier contract and enter into a new supplier contract that, for example, might favour the relationship between a director and one of their related entities, for example, which then imposes a disadvantage or burden on the existing company, then the court is keen to ensure that there are standards of reasonableness and fair dealing in the conduct of officers and members. So it's that underpinning all of that is this sense of fairness. Is this fair, what's going on in the organisational day-to-day of the corporation?
Fairness in business sometimes doesn't go hand in hand, especially when there's minority shareholders. But let's talk about in those cases where the matters run into litigation. And maybe, Paul, this is back to you now in terms of the evidence that is needing to be put together for some of these types of claims. Can you run us through your experience on the evidence front? What's necessary? So,
before I jump into a response there, John, I just want to emphasise that I like doing this. That the role we play as independent expert is really is often we have an overarching duty to the court, and it requires us at times to be quite sceptical and push back on assumptions or the instructions provided. And this is particularly important where the motivating factors of the dispute, like what we're talking about earlier, at the very top of the discussion, can push the accuracy, the commerciality, or the reasonableness of the assumptions that we're given. And to this point, in the recent Dick Smith insolvency litigation in which I was involved, the plaintiff's expert had the majority of the content of his two expert reports excluded from evidence for these very reasons. Now, to answer your question, though, and dovetailing in with, I think, Hannah's discussion on fairness, that we're involved recently in a valuation dispute in which the three of the four shareholders were really leveraging their position to exit one of the founding shareholders in a labour hire and a construction business. Now, based on the plaintiff's experts' initial valuation, they made an offer of 1.22 million. But at mediation, we were successful in getting that lifted to $3.75 million. So I guess the question is how were we successful in that? Firstly, and surprisingly, there was very broad alignment on the applicable multiple. And we will typically, in terms of evidence, we will go to industry reports, recent multiples in terms of acquisitions that have been completed to understand and determine what we should actually use as a multiple. In this case, there was broad agreement on the multiple, even though we came at it from different ways. But like the other expert, setting aside there's some fundamental errors in their value methodology. There are a couple of things that really stood out. One was using evaluation data, and why is that important? Getting that right means that we're actually using the most up-to-date financial statements that are available. And this is, and for a couple of these points on the actual versus hypothetical earnings, and the same with cash flow forecasts, it's really important that we ground our opinions very much on the actual circumstances of the business, and knowing that businesses will continue to change and evolve, but it's really making sure that we come back to looking at actual historicals, and that's general ledgers, financial statements. In this case, there was work in progress reports, access to customer contracts, and also the percentage of completion for each of the jobs that were underway. And then, so when we're doing the forecasts, making sure that they're actually grounded again in the actual circumstance of the business. So this sort of information is fairly well available. And Hannah mentioned a little bit earlier the importance of cash flow forecasts. So this is I just add my little piece here. They're a really important way of managing uncertainty. And, I'm a very big fan or advocate for using 13-week forecasts that are constantly updated as a strong way of managing uncertainty, not as a way of building out, as a way of reducing valuation. And in this case, the plaintiff's expert got involved in preparing the business's cash flows forecasts, which is immediately a sign that they're breaching their independence. And once the experts sort of like start presenting information that is either uncommercial, that they've had a hand in preparing, it means that the reliability of their data, the reliability of their information, and the quality of their opinions is very much diminished. And I just wanted to finish off with this, is tying it back to what I talked about earlier. The company didn't account for work in progress on a regular basis, but we pushed to get that in there. And as I said, and similar to the other evidentiary records I talked about a moment ago, work in progress ledgers, customer contracts, percentage of completion contracts were instrumental in actually making an accounting adjustment to recognise historical WIP as well as future WIP, which prevented a lot of value being ceded to the plaintiff. In other words, had we not done that, the defendant who engaged us would have lost a considerable value in their equity.
Tell me, with some of this that you're being asked to look at, though, is the currency and regularity, or the timing of the information coming together, is that problematic for you? Because you might be coming into things looking at it with a benefit of hindsight rather than live. Is that a concern that you have to deal with when you're preparing your reports?
Yes, it is. Like in a current matter, I've just settled. The plaintiff bring his case for 8 years, and And, setting aside this statute barred element of the claim, there just wasn't the financial records to support his claim. There's a lot of he said, she said sort of thing. And that makes it very, very difficult. We might be instructed to make certain assumptions in our calculations, but at the end of the day, the veracity of those assumptions will get tested. And if they don't stand up and are accepted as fact in the courts, then whatever we quantified will be accordingly reduced. But I mean, that was a fairly extreme situation. But like in the valuation matter I was just talking about, the other valuer, I think, prepared valuation some 15 months or so before mediation was planned. And at that point in time, the business, over that period of 15 months, the business grew substantially during COVID, strangely. And so because the valuer was like quite, stubborn in the ways of saying, no, this is the valuation date, he was actually what had denied the defendant a lot of value. So we were quite stubborn and insistent that we bring the valuation date as close to mediation as possible. That's going to work two ways. In this case, it worked for our client. On the other side, if we were, but your valuation date should be, and the information that you need should be as close to the valuation date and the mediation date as possible.
Yeah, absolutely. Well, I'm delighted to hear that client actually had an uptick during COVID. It's part of that K-curve part. Hannah, where are we at? You've talked about the evidence. We've talked about what the courts might focus on initially, but what can the courts find? What's the outcomes that the courts can take us to? Talk to us about your experience there.
Yeah, sure. So the court will take the extreme step of winding up the company only in a very limited range of circumstances. Some of those circumstances are where there are irreconcilable differences between a company's members, shareholders. In some instances, the court's prepared to make orders to wind up a company where the conduct amounts to oppression, but where they're not prepared to order relief. So that might be for a range of reasons. The other example of where the court's prepared to intervene and take the extreme step of winding up a company is where the working relationships, which when a company is formed, are predicated on mutual cooperation and trust and confidence, where they've broken down to a point where the court cannot be satisfied that the company can continue in its existence in that form. So whilst the court does exercise caution in taking that extreme step of winding up a company, it is also still an option available to it. The other event which may trigger the court to take that step to wind up a company is when the court is not satisfied about the conduct and management of a company's affairs. And sometimes that stems from the failure of those directors who are involved in that dispute to candidly and reflect the affairs of the company, either from the records, the books and records reveal deficiencies, or they're incomplete, or there's been other failings with compliance of the Corporations Act, or a failure to adequately deal with the company's financial affairs. And so when the court is satisfied that there's a lack of confidence in the officers managing that corporation, the court will also take that extreme step of winding up a company. The court is, though, very reluctant to take that extreme step when that such an order will only further the personal or related interests of a third party at the company's expense, or it might be adverse to third parties, for example, employees or financiers, for example, to wind up the company, and priority interests in terms of who ranks ahead of who in a liquidation scenario become relevant. The other orders that the court can make, and as displayed on the screen, there are orders restraining conduct of individuals, orders regulating the affairs of the corporation, and otherwise appointing receiver or manager over assets to preserve usually an interest in a piece of property. The court also is prepared to make orders referable to the shareholding. So whether that is a value that is derived following obtaining a valuation report of that shareholding from a forensic accountant, for example, or otherwise a restructuring of the shareholding of the company to bring about a resolution of the dispute. So those are the sorts of orders the court will make, John.
Okay. We've been personally appointed on a range of court appointments like that on just and equitable grounds, or including receivership matters. And our role has been sometimes a holding role, reporting role to the court whilst proceedings run on. Our experience has been liquidation has an outcome that is liquidate the assets. Doesn't typically allow for businesses to continue to trade. So, our perspective, and I think the courts would align with that, is, if at all possible, how do you save the business? But where there is prejudicial behaviour going on, or not just oppressive but prejudicial to the interests of stakeholders, then they will get involved and appoint that controller, which is usually somebody like myself that comes involved. Hannah, do you want to delve into any sort of little examples there, or are you happy to move on?
I'm happy to move on, I think, but I'll just make one observation, which is probably relevant for many people in the audience, is when seeking a judicial remedy or the intervention of the courts in a dispute, it's really important to liaise with your lawyers in relation to the evidence that's available to you. Often people are charged with emotion when there is a dispute, and there's a very big difference between moral issues with individuals' conduct and perhaps illegality or improper conduct pursuant to the Corporations Act. And so when you kick off an application in the court and you're asking the court to make orders, hopefully in terms that are favourable to you or to improve the situation or status quo, you need to really be prepared to bear all in the evidence that's put before the court, and often that brings up the good, the bad and the ugly of previous dealings with the other directors, and you need to be prepared for the court to throw a fair amount of questions, at least to the legal representatives representing directors, to explain conduct and it's so that the court actually has a controversy or an issue that they need to resolve, rather than just people having a disagreement at a moral or ethical level.
And that can create problems in itself, right? I mean, people go into these disputes with the intention of obtaining an outcome, but it can actually diminish the position. They can cause loss. And that's certainly what we've seen with some of the shareholder disputes leaking into the operational affairs of the business. That's actually a good lead-in. In terms of the alternate restructuring processes and where these matters are running on and they are causing disruption and destruction in value, Hannah, what are you seeing with your clients? What options are you presenting to them when they're running down these paths?
Yeah, certainly. So I think this probably goes against my background in commercial litigation. I mean, I love litigation and I love to have a good fight when it's warranted. But I do think that there's a better way of doing things, and that's ensuring that you've got the right advisors in your circle advising you when there is a prospective dispute. And certainly the advice I give to my clients, the corporate clients that I advise, is to ensure that your advisory team has the right level of expertise to provide you with a pathway forward to resolve the dispute. And that doesn't always result in a first step, let's litigate. What that involves is usually when there is a dispute in a corporation, getting the stakeholders in a room, engaging the expertise of a restructuring specialist to assist with formulating a strategy and options to move the company forward, maximise return and minimise disruption, and getting the expertise of someone like a forensic accountant, for example, to value what parts of the business are in order to inform that strategy as you move along. So the advice usually is to get the right experts on your team, and that is someone with specialist expertise. And second of all, to formulate a plan with all that expertise around you.
Yeah, we've certainly seen that where we get wheeled in from more of a formal perspective, but the provisions under the Corporations Act allow protections whilst these sort of restructuring efforts go on, and I think it's important to delve into this a bit, because where you do it outside of that curve, if you will, or that protection regime, it's people get the benefit of hindsight when they come along after the event to look at how the transaction unfolded. And where Paul mentioned earlier, dealings with the related parties and that could lead to disputes. Well, the Act doesn't allow for the party's particular personal interest to outweigh those of creditors or employees or banks or otherwise. And so what we've seen is people use the safe harbour provisions to take a moratorium and a pause and bring in those experts ourselves or particular parties in whatever industry you're in. Aviation at the moment would obviously be an area of some concern given where we're at the COVID market. But there's also been new provisions brought in, like the small business restructuring regime, which is for this audience. It's I'll talk to it briefly because it's at the lower end, but it's for people, it's for businesses with debts, corporates of less than $1 million, and it allows them a regime to. I call it a mini voluntary administration, but it allows them 5 weeks to reorganise their affairs. They bring in a practitioner like myself, we are registered liquidators, and we talk about a plan, an outcome for the creditors. How is it going to save business, a cash flow, and Paul, bring into your journey of the cash flows, the three-way models about how the business is going to look like coming out the other side, and those. That plan is put to creditors for them to consider, and if they see fit, approve, which effectively ring fences all the issues that were there at that point in time off to one side and allows the business to get on with it. That plan doesn't typically, however, resolve sort of the shareholder type management disputes, and perhaps, and I'll talk briefly to this, is more my expertise, and that's voluntary administrations used to do this process. Where the company can be insolvent or is likely to become insolvent as a result of either these long-running disputes or other contractual matters, we get brought in to act as administrator. And the effect of it is that we take control of the affairs of the business. And the key part there is that we remove that emotion that has been otherwise weighing the businesses down in these ongoing disputes. And we can look at it without issue, without the historical, and look at those performing and underperforming elements of the business. And the voluntary administration regime is quite powerful. It allows us to reorganise the affairs, perhaps deal with underperforming management. There's usually, most problems are led by, are created internally. Putting aside COVID, which is an external factor here, a lot of issues that we see come from internal management, and sometimes there needs to be a change for the benefit of the company to go forward. That could just be a realignment of those different parties' roles. But sometimes it's to move people on, crystallise those claims. It could also be to deal with underperforming elements of the business, the contracts, the leases or otherwise, and to use the moratorium, which is a means for all creditors to have to hold off on pursuing the company whilst this restructure is put together. That process results in a deed of company arrangement. It's a fancy word, or a set of words, I should say, that results in just a compromise or a deal to be cut with creditors. And that deal can compromise those claims, but we also use that to effectively recapitalise the business, perhaps introduce new management, and effectively set the business on its way. And I've done that I've got two examples. I'll briefly talk to them, where long-running shareholder disputes and management disputes have almost sunk the company. And in lieu of continuing on with litigation, they brought us in as a VA. And we did a biotech IT company. It was a really good business, worldwide operation, but run by people with medical expertise rather than business expertise. And they got themselves into a management dispute internally and a shareholder dispute, to the point where nobody else wanted to put in any more money in because they'd run out on the R&D phase. They weren't comfortable with putting more money in when it's not in their interests. Disputes with chief management that weren't performing. So we brought it in, we removed those underperforming elements. We introduced business partners that had those skill sets to complement the medical expertise. And we effectively introduced new capital, got everybody a holiday from their creditor claims for a period of time to be settled at a point, and returned the company to a solvent scenario. In a scenario, by the way, where the shares were realigned such that it could grow into the future. It was a process that took around about 2 months in total, where litigation had run for 18 months to 2 years beforehand, and the internal disputes have been warring. Similar.
But just on that, John, I think that's a really important point to emphasise, is that when you're actually when business owners are involved in disputes, they take their eye off the ball. And so, the longer that dispute runs, the longer the risk is that there will be permanent destruction of value, which is not good for either party.
Absolutely, Paul. I 100% agree. And it's not supposed to. Shareholder disputes shouldn't interrupt the business, but they do in small business land and middle market. Yeah. I mean, that's just the nature of the beast. We had one of that same scenario where it was a foreign-controlled operation here in Australia with substantial Australian property holdings. And there was a dispute between the management here and offshore, to the point where the offshore party just pulled the ongoing financial support. They wouldn't continue to play ball, where there'd been this long-running dispute about how the business would run and the shareholding structure. It caused the business to become crippled in that regard, just like you're pointing out there, Paul, such that we had to use, the voluntary administration process and a deed to ring fence all those issues, to compromise and crystallise some claims, because the underlying business, the assets were good.
Yeah.
But the war between the parties had just brought the business to its knees effectively. But the process we did, we saved the business, used that VA DOCA process, deed of company arrangement, to return the company to solvency, give it its feet again to go forward with new capital. And you'd hope less warring between the internals, because those parties are no longer part of it. In our view, early intervention is always the best outcome. Early the act, the more opportunities, the more options you have available to you to actually deal with the affairs. Hannah, who do you go to? When do you go to get it? And what sort of specialist advice are you seeing? Like, who are you seeing come to you at which points of the journey?
That's a good question, John. Many of the clients that I see are relatively late in the piece in terms of the private clients I do work for. So that's at the point where they have probably left demands a bit long. They've got issues with the taxation office. Basically, the debt pile is piled up a bit too high, and they haven't waved the white flag early enough. I think there's a lot of shame that's probably attached to directors when they feel like it's all a bit much, like they don't want to admit that there's a problem. However, this is a space that we see financial distress in every day. We work in financial distress, and we're really good as insolvency lawyers and restructuring professionals to provide a pathway out of that financial distress. So my view is that, as you mentioned, the earlier the engagement with an insolvency lawyer, a restructuring professional, the better. I think it's really important to properly ascertain the skill set of your proposed expert that you're going to liaise with. The best port of call is to try and ascertain who are regulated by the industry associations that regulate insolvency restructuring professionals, such as ARETA, which is the only industry association that mandates minimum tertiary experience and education in insolvency and turnaround. There are many people that will say they're insolvency experts, but don't actually have the education to back it up, and probably don't have the runs on the board to deliver the best outcomes for prospective clients. So do a bit of research, ask for recommendations, and looking at a RETA as a benchmark to determine who the best equipped lawyers and restructuring professionals are is certainly a good port of call.
And just tying with what you said earlier, Hannah, when you've got a dispute, there's a lot of emotion involved, and sometimes it's getting them to think commercially, which is where we can come as a forensic accountant to give them some sort of sensible sort of idea of what a claim might be worth. Is it worth pursuing? And if so, what sort of numbers would justify going ahead? Or alternatively, and maybe simultaneously, what sort of evidence do I need to bring? So, as you said, the earlier we get engaged, the better it is the stronger role we can help in terms of assisting lawyers determining their legal strategy for resolving that dispute.
Yeah, that's right. I mean, it neutralises the emotion and it maximises the commercial outcome, in my view. Yeah, which is why the independent advisory piece is so relevant.
It's interesting as well, but in my experience, the matters that come to us, they sometimes come too late, and without being disparaging at all, the experts that some of the businesses are relying upon are not insolvency or restructuring experts. They're general lawyers or accountants that are seeking to, Paul, in your case, tip their hand at a valuation circumstance rather than actually what their skill set might be in terms of the modelling or otherwise. And for the lawyer, the lawyer's side of it, I mean, what we deal with on our end, it is very specific. The unfortunate part of that is they burn time and then opportunity by doing that. Final thoughts, if I could. We're approaching the hour. Paul, do you want to go first? Do you want to give us a wrap up on where you're at with this market and what you're seeing going forward?
I think that going forward, there's going to be a big focus on directors' duties. I think that, as Hannah's already highlighted at the very top, there's going to be, I think, all sorts of claims or concerns about how they're managing and governing their business. So I think that we're just potentially at the tip of the iceberg there.
Okay. And with the COVID relief on the laws having now expired, that is going to create some activity for the courts, I imagine. And Hannah, what are you seeing there in terms of go forward?
Yes, certainly. I mean, I've seen an uptick in receiver management appointments. I've seen quite a lot of provisional liquidators appointed to corporate entities. There seems to be a fair bit of mischief that's been happening in the market. There's been a large financing company that has been placed into liquidation in the course of the last week, in which there's over $450 million worth of fraud that's been committed with a major bank around equipment finance. And I think where people are struggling financially, they'll find a way of trying to make a quick buck. So my sort of thoughts are that directors should be very alive to their duties, ask lots of questions, being comfortable that they're discharging their role as a director, knowing that you can be prosecuted for breaches of those directors' duties, and making sure that you're being open-minded to getting alternate advice from a range of specialist experts, such as a restructuring professional. You don't need to be in financial distress to have a discussion with a restructuring professional and ascertain whether there's a better way forward in terms of operating your business or organising your affairs, or otherwise staving off a potential dispute in the future because of a problematic part of the business.
I couldn't agree more. And like you say, they're seeking advice early. There are a range of options available for almost all businesses. I'm yet to find one that it's completely lost. There are some very unique circumstances and challenges sometimes, especially when there's fraud involved and regulators. But there are always various ways to ensure that you can extract value for the benefit of the stakeholders. Look, I think at that point, I might bring it to a close. And I'd like to thank everybody for attending today. Particularly, I'd like to thank the Institute for having us along. Hannah, as always, brilliant to have you here. Well spoken. I value your input and the thoughts. Thank you for your time.
Welcome.
Paul, our forensics head at BRI, well done. He is the professor from our shop internally. Really appreciate your input today. I think there's a lot of good key takeaways for the audience to think about. Thank you, everybody. Stay safe, stay COVID well.
Thanks, John.
Thank you.